What happens when the one piece of evidence that could prove your innocence, the footage of the arrest itself, is deleted by the very person who arrested you? By the end of this video, you'll know exactly what crime that officer just committed, and the single sentence you need to say. The moment you realize that little red recording light isn't blinking anymore. In the spring of 2021, a Georgia police officer was arrested and charged with a felony. His crime wasn't a brawl, wasn't a theft. He deleted his own dashcam video of a use of force incident. And before we go any further, let me be clear. Yes, that is a crime. It's a crime in every state. And once you understand the law behind it, you'll never look at a missing body cam file the same way again. But to see how quickly an officer can cross that line, we have to rewind to the traffic stop where it all started. Picture a dashboard camera's wide-angle lens, 11:42 p.m. on a two-lane road somewhere in the suburban South. The officer is running a license plate on a sedan with a busted taillight. The video shows the cruiser's headlights washing over the trunk, the officer approaching, a brief exchange of words, and then the stop goes sideways. Churn on the won't escalate. Voices escalate, hands go up, and within 90 seconds, the driver is on the pavement being cuffed. The dash cam captures all of it. The sound of a scuffle, the officer's commands, the driver asking again and again, "What? What did I do?" And then, about 2 hours later, that dashcam file vanishes from the department's server. Not corrupted, deliberately deleted. The officer logged into the system and erased it. He later claimed it was an accident, but a forensic audit showed a manual deletion from his own credentials right after his shift. That was enough for a grand jury to indict him on felony tampering with evidence. He eventually pleaded guilty. Now, the question I get as a defense attorney, and the one I want you to walk away with, is this. If you're on the receiving end of an encounter like that, how do you protect yourself before the footage disappears? And what does the law actually say about an officer hitting delete and the legal doctrine that makes this a crime? Isn't some obscure technical statute buried in a state code. It's the simple universal principle that evidence in a criminal case cannot be destroyed. It doesn't matter whether the person doing the destroying wears a badge or not. Every state has a tampering with evidence statute, and while the exact wording varies, they all boil down to the same thing. If you know or believe that an official proceeding or investigation is pending, or about to be, and you intentionally destroy, conceal, or alter an item with the purpose of impairing its availability in that proceeding, you've committed a felony. Georgia's version OCGA section 16-10-94 makes it a felony punishable by up to 10 years in prison in 2021. For deleting his own dashcam video. That wasn't a theoretical legal debate, it was a real prosecution that ended with a prison sentence. When a police officer destroys body-worn or dash camera footage of an arrest, they are not just violating departmental policy, they are destroying evidence. And that triggers criminal exposure at both the state and federal level. On the federal side, 18. USC section 1519 makes it a crime to knowingly alter, destroy, or falsify any record or document with the intent to obstruct a federal investigation. While most street-level arrests are state matters, if a federal civil rights investigation later opens, say, under 18 USC 242, that deletion can become a separate federal offense. So the net is wider than most officers realize. But there's another layer that matters just as much to the person whose encounter was erased. The destruction of that footage may itself be a constitutional violation. The Supreme Court held in Brady v. Maryland, 373 U.S. 83, that the prosecution must disclose material exculpatory evidence to the defense. Body cam video that could show the officer using excessive force, or that contradicts the officer's police report, is the textbook definition of exculpatory evidence. When an officer intentionally deletes that video, they have effectively suppressed evidence that could prove the defendant's innocence. That isn't just a policy failure. It's a Brady violation, and in extreme cases, it can lead to a mistrial, sanctions against the prosecution, or even a civil rights lawsuit against the individual officer and the department for spoliation of evidence. Several federal appellate courts have explicitly recognized that the bad faith destruction of body cam footage can give rise to a due process violation. So if you find yourself in a courtroom and the only recording of your arrest has mysteriously evaporated, your attorney isn't just arguing a missing tape, she's arguing a constitutional injury. Now, how does this play out on the street in real time? Imagine you're the driver. You've been pulled over for something minor, but the officer's tone changes. He asks you to step out. As you do, his hand drifts up toward the chest-mounted camera unit, and you see the small red recording indicator flicker and go dark. Maybe he flipped the switch. Maybe he pressed a button to mute the record function. The camera is still on his uniform, but it's no longer capturing video. This is the exact moment where the law gives you a tool, and it's not the one most people reach for. I'm not talking about I do not consent to a search. That won't help you here, because your Fourth Amendment protection against searches isn't the issue. The right you need to assert right now is your First Amendment right to document the encounter. And I want you to have a specific, calm, repeatable sentence ready. It's this: I have the right to record. I'm not interfering. Say it clearly. Don't scream it. Don't shove your phone in the officer's face. Just say the words while you keep your hands visible. That single sentence does two things that can completely change what happens after the fact. First, if you've already started an audio recording on your phone or a voice memo in your pocket, that statement becomes part of the record. You're narrating the moment the camera went off. A supervisor, an internal affairs investigator, or a judge later hearing that recording will know the exact second the officer allegedly stopped recording. It corroborates your version. Second, by explicitly invoking your right to record, you put the officer on notice that you know your rights. Every federal circuit that has addressed the issue, from the First Circuit in Glick v. Cunnife to the Ninth Circuit in Fordyce v. City of Seattle, has recognized a clearly established First Amendment right to record police officers performing their duties in public, subject to reasonable time, place, and manner restrictions. As long as the recording does not interfere with the officer's ability to do the job. Courts have been extremely clear. Merely holding a phone and recording is not interference. Det är not tampering, not rissing. If the officer then tells you to stop recording, you've already built a protective layer into the timeline of the encounter. You haven't committed a crime, you've documented one. Now let's be practical. If you utter that sentence, and the officer responds by cuffing you for obstruction, your attorney will have a field day. The dash cam, or another officer's body cam, may still capture the audio even if the primary camera is off, and your own recording will show you were non-confrontational. The case law favors you. And remember, obstruction generally requires some physical act. Refusing to comply, tensing your arms, fleeing, saying, I have the right to record, I'm not interfering, while otherwise following commands is not obstruction. I've seen charges dropped for exactly that reason. So the legal landscape is clear. Officer deletes body cam footage. That's evidence tampering and a potential Brady violation. But what about the practical reality that many departments resist releasing footage anyway? The safeguard for the citizen is the public records request. Almost every state has a Freedom of Information law. If you file a written request for the video from that date and time, and the department says it doesn't exist or was accidentally deleted, that response itself becomes evidence. It demonstrates a gap in the chain of custody. Courts are increasingly willing to infer that missing evidence would have been favorable to the defendant when the government fails to preserve it in bad faith. The U.S. Supreme Court in Arizona v. Youngblood clarified that unless a defendant can show bad faith, the failure to preserve potentially useful evidence isn't a due process violation, but the intentional deletion of video by the arresting officer. That's a textbook example of bad faith. So you don't have to prove what was on the footage. The fact that it was destroyed while in the government's exclusive control can shift the entire balance of the case. Let's bring this back to the opening scenario. The Georgia officer who deleted his dashcam video was caught because the system logged his user ID, the timestamp of deletion, and the file path. Digital fingerprints are hard to scrub, but many smaller agencies don't have that level of digital auditing. That's why your statement in the moment "I have the right to record, I'm not interfering," and your immediate documentation afterward matters. Write down the officer's name, badge number, and the exact time the red light went off. If you're in a position to do so safely, call a friend or leave yourself a voicemail, narrating what just happened while it's fresh. The more contemporaneous records you create, the harder it is for anyone to argue the deletion was a harmless mistake. Before we wrap, I want to address one dangerous myth. The idea that if an officer turns off the camera, everything that happens afterward is off the record and legally meaningless. That's false. The law doesn't work like a stage play, where if the stage lights go out, the audience disappears. Your testimony is evidence. A passerby's cell phone video is evidence. A 911 caller's audio is evidence. The officer deleting the video doesn't make the event cease to exist. It just means the officer just committed a separate crime. And prosecutors know this. When an internal affairs file reveals a pattern of cameras mysteriously failing only during a particular officer's use of force incidents, that officer becomes a liability. I've seen cases where the state's own expert testifies that the metadata shows the camera was manually deactivated seconds before a physical altercation. That doesn't help the state's case, it sinks it. So what do you do if you're the person standing by the side of the road, heart pounding, and you realize the red light just blanked out? You stay calm. You don't announce that the camera is off in an accusing way that escalates things needlessly. Instead, you simply vocalize the right I gave you. Then, as soon as you are legally permitted to have your phone, you turn on your own recording device, even if it's just the voice memo app. And as soon as you get home, you write down every detail, while your memory is sharp care. You also find an attorney who understands evidence preservation letters, because a properly worded preservation demand sent to the agency within hours can freeze the exact server logs and metadata that might otherwise be overwritten. The truth is, body cameras and dash cams were sold to the public as a tool for accountability. But when an officer believes he can delete footage without consequence, that camera isn't an accountability tool. It's a trapdoor that swallows the truth. The law, however, has already built a ladder out of that hole, using statutes like OCGA Section 16-10-984, the Federal Obstruction Statute, and the constitutional mandates of Brady and the First Amendment. The key is knowing how to grab that ladder before the footage disappears. Now, if you're thinking this only happens in high-profile cases, let me leave you with this. The routine traffic stop that goes bad rarely makes the news. The deletion often gets discovered only because a defense attorney pulls the metadata and finds a gap where a recording should have been. Without that scrutiny, it simply looks like a camera malfunction. And once you understand how evidence tampering charges work, you'll never look at a missing body cam file the same way again. Which brings us to a closely related question. If the dash cam suddenly goes missing from a police cruiser after a crash, who's actually on the hook? That's a story for another day. And that's the same law used to convict the former local district officer, Aldo Conti.